Hey, today I want to talk about the Georgia Code, section 24, 412, which is to do with presenting evidence in court relating to the past S behaviour of the complaining witness. And this issue raised a lot of controversy, I guess, in the Edrick Faust case because it was the reason that Attorney Cruz was held in contempt on day one of the trial. So when I was watching the trial, I couldn't understand why Attorney Cruz didn't file one of these, because that's what they kept saying in court. And I watched the trial with Melanie Little. She had a look at the docket and found this 412 motion that the defence did in fact file. So they filed this regarding needing to introduce evidence related to Tara and her ex-boyfriend, Chris Melton. So that's what the motion was about, and that motion was granted. So that's why they were able to question Chris about his relationship and that kind of stuff with Tara in the trial. But it's not as simple, because they needed to provide evidence and reasoning for why they would want to include that as evidence. So the problem is they didn't have evidence of that, because you need to be able to show that someone else other than the defendant was the source of the semen, etc., or the fact that there was consent, or specific instances of a victim's sexual behaviour with respect to the defendant or another person if offered by the prosecutor, blah, blah, blah. So they have to file the motion that describes the evidence that they have, why they want it to be offered. It has to be done 3 days before the trial, and then it has to be granted. The judge has to decide whether it's going to come in or not. So the state and the defence put in their 412 motions, all regarding Chris Melton. There were a couple of things that Cruz tried to do during his opening statement, and one of them was he talked about the witness that that police didn't follow the lead, where a week after the crime, someone named Jessica Gann rang the police and said that she thought that she saw Tara with a group of friends that night, the Thursday night, and at a Mexican restaurant. So Cruz wanted to be able to put forward that there might be another way for Edrick's DNA to end up where it ended up. And that could have been through contact in another environment, because we don't really know if she went straight home after the library or if she went somewhere else. So the context that he wanted to present that was to show that that law enforcement didn't follow that lead. So their investigation was not up to scratch, I guess. And just to provide an alternative, like there are other ways that DNA can get somewhere. But the DA objected, obviously, and tried to say that he was trying to introduce that under 412. As we know, the defence ended up resting without presenting a case, and they were going to try and present that information about the tip that the police got in 2001 about the Mexican restaurant. However, they weren't allowed to for some reason. I can't remember exactly why. I think it's in another one of my videos, but that wasn't allowed in by the judge anyway. So, and I don't think she'd ruled on that prior to the opening statements anyway. So that's why he talked about it. So this guy here, Colin Miller, he is from the University of South Carolina, from the Joseph F. Rice School of Law. He is Professor of Law and Thomas H. Pope Professorship in Trial Advocacy. And he served as a professor at the John Marshall Law School. He is the creator and editor of this blog that we're going to have a look at in a second. And his areas of expertise include evidence, criminal law and procedure, and civil procedure. And blah, blah, blah. So he has lots of qualifications and things. So he knows what he's talking about. And he became interested in this case. This is my cat. I think she wants to be let out. Okay, so he became interested when he saw all of these shenanigans online, and this is something he wrote about the 412 thing and Attorney Cruz being held in contempt. So if you want to have a look at that for yourself, it's evidenceprofblog.com, and he just talks about what is the rape shield rule and how it's supposed to be used. So it says it's a subspecies of character evidence rules which prohibit parties from presenting evidence to prove things such as once an arsonist, always an arsonist, or once a burglar, always a burglar. So he talks about this part of the opening statement where during the interview with Chris Melton, Lizzie and Jero said, "Hey, we found another person's DNA, nobody." And Mr. Melton's response was, "Sounds like she was with someone else." So that's when he got held in contempt, and this guy goes on to explain, what's his name again? Colin, goes on to explain what Cruz was actually doing. He was relaying to the jury what GBI agents told Baker's boyfriend about the crime charged, and then explaining how the boyfriend responded. So he's not trying to reference anything about any other S act involving Baker. He was just trying to tell the jurors what happened when the boyfriend was told about the crime. So, and he just talks about how that's just really derailing the defense before the trial really even started. So I think that is pretty bad. And the thing that I also find, I guess it's just the double standards. So the only evidence that the state had was that DNA. But anytime the defense tried to talk about the DNA and put it into any other type of context to try and explain it, because remember, it was male DNA, but it wasn't sperm. So there are other ways that DNA can get to places, right? But then they just kept bringing up this 412 every single time that Cruz tried to talk about that, and it doesn't always fit. And yet the prosecution can just make really broad statements with no evidence whatsoever to back it up, like he broke into her house. How did he break into her house? Because the photo that they showed of that window with a little bend in the frame, come on, the doors were locked. So how can he commit burglary and break and enter or whatever it is if they didn't actually provide any evidence to show that the house was even broken into, number one, and number two, that it was him? So I just find, the double standards just so irritating. And then Yamalama Ding Dong is trying to say, oh, the Edrick's DNA was found in her mouth and in her vagina. I'm sorry, but the presumptive test hasn't actually definitively proven what type of swab that was. We don't know enough about those cuttings of swabs. That's what they were. They were little cuttings. They weren't even the actual full swabs. Plus, they were 23 years old, 22, 23 years old when they were tested. Samples degrade over time. It's just, you can't make those kinds of massive assumptions, I guess, without the scientific backing. It just really annoys me that they kept using that. So, in my opinion, I do think that the state used that particular code, the 412 code, to limit the defense, basically, just to limit them in a way that is way too broad, and I don't think it actually was correct within this. And I also think that the DA is so dramatic, and I'm not sure if he really doesn't understand when Cruz is putting something forward. Does he really not understand, or is he just pretending for the effect to sort of put him down and make him seem less credible? Because if he's the district attorney, I mean, he's supposed to be pretty switched on, but who knows? Who knows?